Okay, g'day students. Here is a very quick run through of the syllabus dot point from Unit 3, which covers Federalism in Australia. It's one of the meatiest syllabus dot points in the entire ATAR course and is one of the most likely high mark questions you may get in the exam for the Unit 3 questions, which of course are half of them. So here's what the syllabus says. So I'll do my best to quickly cover all of this stuff. So you have to know something about federalism in Australia with reference to the constitutional powers of state and commonwealth parliaments, including exclusive concurrent residual powers, and those following sections 51, 52, 90, 107, 109. The financial powers of the Commonwealth Parliament, including taxation power, tied or special purpose grants, including section 51, subsection 2. 87, 90, 92 and 96. The change in the balance of power since Federation with reference to financial powers, including the vertical fiscal imbalance, the horizontal fiscal equalisation and the Grants Commission. Referral of powers, section 5137. CoAG, cooperative federalism as opposed to coercive federalism, and what the High Court has done in particular interpreting those three sections, section 5129, section 5120, and section 51.2, 90, and 87. All right, so let's get into it. So I think probably the best place to start is with CoAG. So CoAG is a relatively recent instrument, created in 1991. It's recent for me, probably ancient history for you, but it hasn't been around for that long, and it's was designed to improve the level of coordination and consistency of law and administration across the country to meet the demands of a increasingly globalized world. So things like making sure that laws are consistent across jurisdictions, even though they're technically part of areas of residual power, and having partnership payment agreements to better resource the states so that there's like I said, not just consistent laws, but the consistent administration of those laws. So some examples here from recent times is the National Disability Insurance Scheme agreements between the Commonwealth Government and the states, where the federal government has stumped up quite a bit of cash to make sure that the disability insurance scheme can be the same Australia over. And the Closing the Gap Intergovernmental Agreement, where once again the federal government provides funding so that the states can attempt to meet key performance indicators in helping Indigenous people close the shocking gap in life expectancy, health outcomes, educational outcomes, housing, and so forth. Now, so the question is, why are the states willing to come to the party here? Why are they even entertaining making their laws less unique, given the idea of federalism in the first place is that the states retain their own identities, their own autonomy, and can, legally speaking, go off in their own directions? Well, the answer is basically money. States need money, federal government has lots of money, and so they, perhaps somewhat unwillingly, will agree to these cooperative arrangements. So that leads us to the next question: why do the states need money so much? And that's where we begin our a very key concept in the syllabus is the vertical fiscal imbalance, and it's really simply expressed. All it simply is referring to is that the vertical part is referring to the fact we have tiers of government. If you imagine it like a wedding cake, we've got federal at the top, states in the middle, and if you want to include local government too, even though you're not really required to for the purposes of your ATAR exam, local down the bottom, and essentially there's an imbalance because the federal government has more money than it needs, and the states have less money than they need. And how do we define how much you need? Well, it's based on what you're responsible for, what you have to pay for. So, for example, the states have to look after health and hospitals, and health and hospitals are really, really expensive, and it's your job to pay for them. So that's the situation we've found ourselves in recent times: is cash-strapped states increasingly coming cap in hand to the federal government, asking for more and more money, and the federal government is willing to give the money, but they also want influence, and that's really the point you need to make in your exam, and that the federal government has increased its power largely through this big bag of money that they have to offer the states. So, how has the federal government increased its financial power over the states? Very briefly, so things started the minute the Constitution was signed, because Section 90 gave the Commonwealth Government a huge win in giving them the exclusive right to customs and excise taxes or duties. Very, very big tax, which reaps a large deal of money. So because of the word exclusive in Section 90, by definition, the states were shut out, and they could not raise customs and excise duties of their own. Section 87, however, did promise to give 75% of this revenue back to the states, but it had a sunset clause of 10 years, meaning January 1st, 1911, the Commonwealth Parliament was no longer required to hand that money over, and they could keep it for themselves. Then in the 20s, we have the Loans Council, which restricted the states' ability to raise their own funds by, borrowing money from money markets. And the state governments could still obviously borrow money, because most governments do. They're constantly borrowing money to run the country and run their areas, but the Loans Council meant you could only raise the money if it got the approval of the Loans Council, and I believe each state had a vote on this council, and the federal government would have 2 votes. And so theoretically, a state government seeking maybe to avoid being told what to do constantly by a federal government, wanting to borrow heaps and heaps of extra money from outside sources, could have those loans rejected by the Loans Council. A small point, but a point nonetheless. Then we have the Uniform Tax Agreement in the middle of World War II, which of course is incredibly important, because this was the series of laws which enabled the federal government to take all the income tax. Okay, income tax is huge source of revenue for governments, and before 1942 the states were able to raise their own income tax, because unlike customs and excise, the federal government's ability to raise income taxes is from Section 51, subsection 2, and hopefully you know by now, Section 51 is concurrent power, meaning both state and federal governments can make laws with regarding to them. But after 1942, that was no longer the case, and the federal government got all the income tax, and the states lost all of their income tax. A huge financial blow. To somewhat recover from this, the states started to find other ways of raising revenue, like increasing stamp duties, for instance, which is the tax you pay on the sale of property, in particular houses. And the other thing that they started to do was they started to raise higher and higher licensing fees for substances and services that require a good deal of regulation, like the sale of alcohol. Okay, alcohol needs to be regulated in the sense that you have to make sure that the alcohol is safe for human consumption. You have to make sure that it's not being sold to minors, and so on. So that means liquor licenses were what liquor stores would pay, or pubs would pay, to help pay for that regulatory activity. And there's a significant case, which I'll discuss a bit more later, which killed the large licensing fees that were being charged in many of their states. And finally, in the year 2000, we have the invention of the goods and services tax, which one of the big selling points for John Howard's GST was that all of the money would be given to the states. However, what he failed to mention at the time, I suppose, was that it would be done on essentially an as-needs basis. So they invented a policy called horizontal fiscal equalisation, meaning, yes, the states get the money, but which states get how much money? That became a political issue ever since the implementation of the GST. Okay, so that's a bit of a rundown on the main financial reasons why there is a VFI now. So, Section 96 needs to be known. And this is the grants of money can be given from the federal government to the state governments on such terms and conditions as the Parliament thinks fit, which means they can attach conditions to the offer of money. Here, have this bag of money, but we want you to do something for it. And that's been the key vehicle to help the federal government interfere with areas of residual power. Okay, so tied grants have become increasingly used since the days of Whitlam. Just quickly show you how much we're talking here for Western Australia in 2019-20 financial year. So here we are. Here's the West Australian budget for tied grants. As you can see, they're Commonwealth tied grants. Here's the 1920 financial year, and if you go down, so it's got all these payments. Whoops, go away. Okay, so it's got all these payments for health. So as you can see there, the National Health Reform Agreement. So that would have been done through CoAG, and you can see there, $2.3 billion. And all these other relatively smaller tied grants as well. Then we have education, and again the National School Reform Agreement, another CoAG thing. So that's nearly $1 billion as well. And then we've got some more stuff on skills and workforce development, affordable housing, community services, transport infrastructure, the environment, other, which is legal aid and so on. And we eventually get to the bottom here, $5,110 million, or $5.11 billion. That's just in one financial year. So you can see what a big deal tied grants are. So that all of these payments are payments from the federal government to WA, as long as we meet or agree to meet the conditions of the grant. Okay, so that's federal influence in areas of state power, because all of those things listed here, health and education and so on, are residual powers. The federal government, in theory, is not meant to be able to affect policy outcomes in these areas, but of course they do, thanks to the money. All right, back to the presentation. All right. So the history of Section 96, the states did challenge to what extent you could put conditions on the grants of money through Section 96, but the High Court shot that down and said pretty much most conditions will be allowable, since Section 96 is fairly straightforward in its language on such terms and conditions as the Parliament think fit. So that was that. and no real restrictions on what sort of conditions you can place on the money. Now, apart from the money, the other big reason why the power has shifted in favour of the federal government over the last century and a bit is the High Court, and through their interpretation of the words that exist in the Constitution. As you guys should know, the Constitution essentially is a distribution of power. Okay, it decides who gets legislative power, who gets executive power, who gets judicial power, the limits that will be placed on each and every one of those arms of government, and also, since we were creating a federation, what powers would the federal arm of government get, and what powers would be left to the states. And so if you can interpret those things as the High Court, you can see how they can have an effect on the power shifting towards the federal government, or the other way if they so chose. But it seems like most of the cases that have happened over the years have favoured the federal government. So, first big one mentioned in the syllabus is Section 5120. This is the corporation's head of power, and originally, before the engineers case of 1920, there was a doctrine called the Doctrine of Implied Immunities and Instrumentalities, and just in plain English, this really was just an approach towards Section 51, which treated pre-existing state laws as immune from interference by the federal government. So if a state already had a law in that area, you could not make a federal law that with the intention of overriding it or interfering with it in any way. But then the engineers case happens in 1920, and the High Court abandons this doctrine and says, nope, we're going to take essentially a textual analysis. We're not going to read into what the states and the federal parties were thinking at federation. We're just going to look at what it says in the text. And in the text, if it says the federal parliament can make laws about these areas, and of course on top of that with Section 109 saying where a federal law and a state law conflict, the federal law shall prevail, it was the first death knell for state autonomy in our federal arrangements. And of course, it's been taken to an extreme that no one really expected in 2006, when they again reinterpreted Section 5120 to expand the meaning of what a corporation was, or the corporation's power was, to include not just financial corporations, but also the prescription of industrial rights and obligations of corporations and their employees, and the means by which they conduct their industrial relations. So a massive expansion of what the corporation's power meant from previous cases. And this, of course, meant that the work choices legislation made by John Howard was declared to be constitutional. So massive news there for federalism. Okay. Then the aforementioned income tax takeover. So this again happened in the middle of World War II. It was indeed challenged in the High Court, saying that the four acts that they passed amounted to essentially an inducement for the states to give up unwillingly against their will, a coercion or an inducement against their will to abandon their income tax. So they were using words to avoid the word bribery, but that's basically what the states were accusing the federal government of doing, because they were going to increase their income tax, the federal income tax, okay, to match existing state levels. Of course, they have the power to do that because it's Section 51(2). They can raise their income taxes. It's very plain English, very incontrovertible. Then the Grants Act would give a grant, again, so a tied grant to each state, as long as it did not raise its own income tax. Thirdly, we had this interesting section, Section 221 of the Income Tax Assessment Act, because this was deliberately written in a way that Section 109 would kick in, because it said Commonwealth tax must be paid before state tax. And that was very clever, because you can imagine the states wanting to keep their income taxes could have written into their law, you must pay the WA tax before you pay the federal tax. So the federal government made sure that wouldn't happen because of Section 109. And then finally, they compulsorily acquired the equipment officers and staff used to collect the income tax from the states, crippling their ability to collect the tax anyway. And the states contested this in the High Court, and the High Court chose to say that each and every one of these acts was consistent with the Constitution. And from that day forth, states abolished their income taxes, and the federal government took all of it over, and this financially crippled the states ever since. Okay, external affairs was mentioned, so quickly go through this. This has been a very important instrument for expanding federal power into areas of state control, traditional state control. So Tasmanian Dams is a really nice, easy case to understand. You don't really need to know much of the facts about it, but essentially it was the federal government wished to enforce an international treaty they had signed, which is the World Heritage Act or the World Heritage Agreement, and the Tasmanian government wanted to build a hydroelectric dam on the Franklin River. So the Commonwealth tried to stop that, citing external affairs as the constitutional instrument through which they could override the Tasmanian law. The Tasmanians said, no way, this is hydroelectric power. This is what that's a residual power, you can't interfere. But the High Court disagreed. They said, yes, the Australian government would be a laughing stock if we were unable to guarantee our international obligations that we have promised to the international community by signing these international agreements. So for that reason, the meaning of external affairs was increased to include internal affairs that are connected to our international obligations. And from that point forth, the federal government was able to much more easily interfere with areas of state control. So another good example of that is Toonan. So Toonan, again, Tasmania, funnily enough, there was some anti-criminalisation of homosexuality in Tasmania, and Toonan was a bit of an advocate for anti-discrimination in this space. He was essentially fired from his job because the Tasmanian government insisted that he get fired. Otherwise, the government department or the company he worked for would lose its funding. And he took that all the way to the United Nations, and the United Nations said, yes, your case, the Tasmanian laws are a clear breach of the International Covenant on Civil and Political Rights. And once that was declared, the Commonwealth government went, all right then, well, we've signed the ICCPR. That's an external affair, and therefore we now have the power to abolish the criminalisation of homosexuality in Tasmania. And of course, as we all know, most criminal law is dealt with by states, but not on this occasion, because external affairs expanded into that area and allowed the federal government to interfere. So there you go, a couple of examples on external affairs. Okay, so interstate trade and commerce has to be absolutely free, according to Section 92 of the Constitution. And at first, as you can see, the bank nationalisation case, the interpretation by the High Court was that it would prohibit all laws that had any effect on interstate trade and commerce. But then in the 80s, the Tasmanian crayfish case, they reinterpreted Section 92 to be a little bit less strict. They said it only prohibits laws that have a protectionist burden, on interstate trade. So that meant, of course, even though the Commonwealth government wasn't even involved in this case, and yet they were the main beneficiary of the result, because the relaxation of Section 92 meant the Commonwealth government could start making laws that would affect interstate trade and commerce, as long as they weren't protectionist in their intent. The aforementioned customs and excise duties and the licensing fees, so the issue of that. So the state started jacking up their licensing fees to try and raise money, because of course their sources of revenue were drying up elsewhere. And eventually the people that were paying the fees got sick of it, and they took it to court, the High Court, arguing that these weren't in fact licensing fees. And the High Court agreed. They said they weren't really licensing fees, because the purpose of a license fee is to help pay for the regulatory requirements that government has to pay for. And when you're going beyond that, when the licensing fees are so high that only a small portion of it is to pay for the regulation, then what you're really doing is raising revenue, and that makes it a tax on goods, a tax on alcohol, cigarettes, and so on, and that classifies it as an excise. And sorry, states, you can't raise excise. That's a exclusive power of the federal government. So bad luck to the states. Another nail in the coffin for financial autonomy for the states. And hopefully that has covered everything that you need to know on federalism. And I wish you all the best in your exam.